Welcome to Landmark Law. Thank you for tuning in to our legal education seminar on wills and estate planning. My name is Winnie Luck Taylor, founder and principal lawyer of Landmark Law Professional Corporation in Markham, Ontario. Landmark Law provides professional, quality, and affordable legal services in wills and estates planning, corporate law, and real estate. And we're pleased to provide this webinar to you. And for more updates on future legal topics, kindly like or follow us on Facebook. Before we begin, please read our disclaimer. The contents of this presentation is for informational purposes only and do not provide legal advice to the viewer. It also does not create a lawyer-client relationship with the viewer. Now let's get started. We're going to cover why do we need to make a will? What are some major considerations in a will? What are powers of attorney and the major types of powers of attorney? Followed by some basic tax planning information, frequently asked questions or common scenarios. Then we'll open the discussion up for some questions and answers from all of you out there. So if you have questions about this presentation, please comment, and at the end of our presentation, we will answer them. So why do we need a will? Having a will ensures that you're able to care for your loved ones and have your wishes honored. By having a will in place, you're able to appoint guardians for any minor children that you have and provide support for family members with special needs. When you don't have a will, generally the government may step in and make decisions on your behalf, which may not necessarily align with what you would have wanted. By having a will, it eliminates burden and expenses. Having your instructions clearly documented can help to reduce family disputes and potential litigation. I have a client who, within 2 months of starting a litigation file, was already $25,000 in legal expenses. So this was with another firm. And approximately 6 months later, it was clear that this case that brought upon by the challenger was not going to continue, as the challenger was going to decide to withdraw, probably because of being tapped out in the legal fee funding. And by then, our client was already in the hole around close to $75,000 just to help defend. So it's a realistic goal to try to avoid family disputes and potential litigation. And sometimes when these cases get settled, which means that they get divided, the result, rather than having a winner or a loser, there's a compromise, meaning it gets divided. In some cases, even the legal fees may be deducted from the estate. So it's a realistic goal to try to prevent family disputes and potential litigation in order to preserve more estate to your loved ones, okay? And also reduce, the stress and being able to have your estate distributed to your beneficiaries the way you wanted it to be. By having a will, it also reduces administration and potentially probate fees. I'll talk a bit about this. So when you prepare a will, the will maker has to appoint who's called a trustee. A trustee is the person who you trust, who would oversee the administration of your estate, follow the wishes in your will to give out and distribute the estate according to your wishes in the will. It's often referred to as an alter ego. Like, if you're not here, who's the next person who would take your place and would understand and be able to follow through with your wishes. And a good way to remember who this person is that the word trustee has the word trust. This is a person you trust who's going to take your place and do what you would have done and follow your wishes, who you believe would be the best person to do this. Okay? So you would appoint this person, the trustee would take your will when you passed away and attend a lawyer's office and have what's called a application for a certificate of estate trustee with a will filed, an application for certificate of estate trustee filed. In short, I'll call this probate application, probate process, probate certificate. I'll use the word probate because that used to be the language used in the past, and it's easiest to remember. So your trustee goes to the lawyer to have a probate application prepared, to start the probate process, and to obtain the probate certificate. Okay, and in order to go through with the probate application process, it is a lot smoother when you have a will. Okay? When you don't have a will, there's more paperwork involved because the person left no instructions behind. There was no will made, so there's more paperwork to determine who's left behind, who are the next of kin, and who would be the best person to take the assume the role of trustee. There are guidelines under law, but there's definitely more paperwork, more consents and approvals required, and more expenses and fees incurred to go through this process, and more time involved. So I had a couple of cases last fall involving probate applications, and for the client who did not have an application, who did not have a will for her late father, that process took 13 months. Okay, and for the client who did have a will, this was for a mother, the process took 6 months, so approximately double the time. Of course, the time varies depending on the workload of the estate office. However, in general, when you don't have a will, it takes longer than if there was a will in the first place. And not only are there more costs incurred, more time and energy expense, there's also stress because while the probate certificate is being processed, the beneficiary is waiting. It could be waiting for their share of the estate, the bank account of the deceased, the title of the home of the deceased will still be sitting in the name of the deceased, and those cannot be distributed until the court has completed or the estate office has completed its probate application process and issued the probate certificate to the trustee, which would then give the trustee the right to approach the bank, go to the teller, show them the will, show them the probate certificate, and then get access to the funds to deliver according to the will instructions, or get access to the land registry office through the lawyer to change the name from the deceased for the home ownership to the beneficiary, or to the estate and then the beneficiary. And by having a will properly executed and going to a law firm to get the will prepared, the client, the will maker, can consult with the lawyer. The lawyer finds out more about the situation of the will maker, and the lawyer could then perhaps provide some advice that might help the will maker reduce probate fees. So I talked about the trustee bringing the will to the lawyer's office to prepare the probate application. In the probate application, the application requires that the value of the estate be calculated, and then the tax rates in Ontario would be applied to that value. And the taxes, which are called estate administration taxes, and we're going to cover this more in our seminar in a few slides from now, would have to be paid as part of the complete probate application process. And by having the consultation with the lawyer might be able to come up with some ideas to reduce these probate fees and taxes. So what are some major considerations in a will? Firstly, the will maker must have a clear mind and have made their wishes or instructions without any influence from a third party. So sometimes our office would get phone calls from adult children who would like to arrange wills for their elderly parent and proceed to tell me what to write in the will or the powers of attorney. And our response to that is our firm must speak directly with the elderly parent to get the personal instructions from this will maker client, because we cannot take instructions from anyone else except for the client. A will and power of attorney are matters of personal concern. Okay, so and so make sure that if you don't have your will and power of attorney, that you get it now. Don't wait for the unknown, because the unknown is unknown. You don't know if you might not have the ability to prepare one later, and then by then it's too late. Meaning, if you have dementia, if you're sick, you're just not around anymore, and you don't have this in place. As we mentioned in the previous slides, there will be more burden expenses, potential litigation for the families involved. So get it done. Okay. Regarding duress or undue influence, so going back to our last example, if we have the client, elderly parent come in, very often the client is accompanied by family members, and if there's a whole bandwagon of people joining, well, first of all, we must meet with the will maker privately. So we would have our client sit in a meeting room with us, okay, to give us instructions. And we've had cases where we had our own staff provide language translation if we're able to. And if there is a language difference and there's no way we can understand, that's the end of the story. We can't serve a client that way. But there are firms in the community with different language capabilities. Okay, and that's the rule. You cannot bring in a family member to translate. Okay, any translation is done by a law firm personnel. Okay. So in this situation, if there's a lot of people in the waiting room, I would ask the will maker about the circumstances, like who are these people, why are they here, and rather than one single driver, right? So, and the reason for this is that we do need to take notes. We need to take notes for compliance purposes in the future. If there is a legal challenge to the wills, okay, often the most common challenges to a will are, okay, there's always a challenge that the will maker did not have a clear mind to prepare the will. The second major challenge, they always come hand to hand, okay, they always go together, is there are suspicious circumstances behind the preparation of will, and that's sort of where we get the notes. Of course, we don't know the personal lifestyle of the will maker. That's the litigations are there to sort of interview people and probe for details, but we're involved in the process as a witness, and we supply the information that we have, and we do also want to safeguard and protect the wishes of the will maker. If the will maker was very clear and has a sound, clear mind in telling me what he or she wanted in the will, my notes will determine if under reasonable circumstances that this a will is valid. Okay. The next point, of course, is that you have to appoint the names of the people, the beneficiaries, who will be receiving the gifts under your will, the guardian for any minor children, and the trustee. So we talked a lot about the trustee. It's the person who you trust who's going to oversee the administration and the distribution of the gifts under your will. You trust this person a lot. And the guardian is who looks after your minor children, and the beneficiary gets the gifts. And you can appoint these people, and you can also appoint substitutes. So who would rank next if the people you picked as your first choice were no longer here, or they cannot assume the role, and even beneficiaries, they could refuse gifts too. Okay, it doesn't always happen, but it could. It could happen if someone were to receive a house, but they don't have the ability to maintain it, pay the taxes on it. They could refuse, or they just don't want it. Okay, but anyways, it becomes more relevant in the roles of trustee and guardian. Okay, they can later in life they can end up moving out of the country, or become sick, or pass away even before the will maker. You can appoint substitutes, and you can appoint more than a single person at each level. Okay, so in a standard will, for example, a married couple can say, "I give everything to my spouse." Or, sorry, I appoint my spouse as trustee if my trustee is not available, or no longer here, or able to perform the role. I appoint my two children to act jointly as the trustee. You can do that. You can rank, or you can have multiple people acting jointly. Okay. And your distribution of your estate, you can have a very simple standard will or a detailed one. So standard one is, I give everything to my spouse. If my spouse has passed away before me, I give everything to my children in equal shares. So that's standard. It's divided in a very even way. There's no one being favored over the other. And if it talks about everything as a percentage, it doesn't try to add up everything I own to total what I have today, because as you go further in life, your estate will change. You can have more things, you can have less things, you can move. So this covers it all, and it's the most popular choice. I would say 95% of my clients do a standard will and powers of attorney, so much so that we do offer a standard wills and powers of attorney discounted package. Okay. As for detailed wills, there are people who are particular. They want to pass on their investment condo to person A, their bank account to person B, select cash gifts to persons C and D, heirlooms, and so forth. And very important, okay, you can see in bold, Affidavit of Execution and Exhibit Stamp. If you were to remember anything about this, remember this line item in bold. If we do, I do this presentation in person a lot in a boardroom, and we often have a trivia form, and this is often the question on the trivia. So remember this. Affidavit of Execution is a document where one of your witnesses must appear before a lawyer, notary public, or commissioner of oath to swear or affirm that the witness in fact saw the will maker sign the will in the presence of him or herself and a second witness. And the affidavit refers to a will marked as Exhibit A. And that leads us to the next part of this bolded point. There is an exhibit stamp on the back of your will, which is on the back page of your signature page. There should be a stamp that says, "This is Exhibit A, referred to in the affidavit of so-and-so witness, dated so-and-so date," and that should be signed by the same lawyer, notary public, or commissioner who signed the affidavit. Signatures should match. References to the affidavit and witness names should match on the affidavit of execution and the exhibit stamp. If you already have a will, then please check for these. So it's likely that you would have the affidavit of execution if you prepared this at a law firm. The affidavit of execution actually should say, or it normally would say, Form 74.8. It normally would. If it doesn't, that's okay, but it's an affidavit of execution, 74.8. And check the back of your will behind your signature page for a stamp. If it is blank, please go back to the law firm who prepared your will and ask for that Exhibit A stamp that is referred to in the affidavit. Because if you read the affidavit of execution, it actually says, it's referring to the will marked as Exhibit A. So the will has to be marked, so it shouldn't be blank. So make sure it's marked, and the stamp is on the back page of the signature. That's very important. I've had a couple of clients approach me last fall, and they're trustees, and they brought the wills of their deceased parent to me, and I had to send them back. I had to say, it's not complete, and I can't file your probate application because it's missing the stamp. And I had to provide instructions. One of them, I had to send the person back twice because when it came back to me, the stamp was on the front. And I believe the law firm put it on the front because in other court documents, the stamp is on the front. It's an Exhibit A, and it's on the front. But for wills in particular, the guidelines from the court is that it has to be behind the signature page on the will. So if you go to our firm to get your will done, it will be done properly, and we won't be having to call the trustee to come back to collect it. So what are powers of attorney? Power of attorney is an instrument where you appoint somebody to make decisions on your behalf. Okay? And a will and a power of attorney is triggered when you're still alive, but you're not able to make the decision yourself, either because you're not available or you're not mentally capable of making decisions. Okay, and I did mention dementia in a previous slide. It's different from a will. A will is triggered upon your passing, and it has to do with instructions on where you want your estate to go to, who you want to give your estate to. Power of attorney is about who do you give authority to make decisions on your behalf when you're still alive, okay? And when you don't have a power of attorney in place, the government may get involved to decide who's your decision maker. And often you have what's called a guardianship application, and we need to do an assessment on the mental capacity of the person. This person's called, it's got two names, the donor or the grantor. So let's just say client, because I can't really say will maker, or the power of attorney maker. It's a bit more complicated, and when it's complicated, there is more stress, there's more time involved, and there's also more costs involved to do all of that. So as I mentioned before, it's good to get your paperwork and your estate planning done today rather than waiting for the unknown, because it's really complicated and expensive and stressful. There are two major types of powers of attorney, but there's also an unlimited list of them as well. You have these two, your bases are pretty much covered. So one is the power of attorney for property. It basically covers your legal and financial decision maker. It covers the filing of your tax returns, managing your bank accounts, investments, real estate, and business. So you see in the title, power of attorney for property, it actually doesn't refer to real estate property only. And I get that question a lot from clients. Property is a legal term that basically means all your affairs, okay? But it doesn't include your personal care decisions. So That's the next power of attorney. Power of attorney for personal care, also known as a living will or advanced care directive. And here you appoint somebody to look after your personal care needs, such as decisions involving your nutrition, health care, shelters, hygiene, clothing, and safety. And it often contains a clause on if you should be diagnosed with a terminal illness where there's no hope for recovery, that you wish to not be placed on artificial life support and pass peacefully. So this is in the power of attorney if that's your wish. And when you don't have it, it's complicated. And you might have heard stories about people being on life support for several years and the family are not able to uh, get them off. So it's important to have this in place if that's what you would have wanted. Okay. And state administration taxes, we talked about how the trustee has to bring the will to a lawyer's office to prepare a probate application in order to get a probate certificate in order to proceed with the distribution of the estate according to the wishes of the will. In the probate application, the value of the estate must be calculated and the state administration taxes must be calculated and paid to the Minister of Finance. So in Ontario, we experience the highest estate administration tax, I'll say probate tax rate, okay, at 0.5% for the first $50,000 value in estate. For all amounts above $50,000, the rate is 1.5%. And here's a table to reflect on what that might look like for a $1 million estate. That's approximately $15,000 in taxes, $2 million, $30,000 in taxes, $5 million, $75,000 in taxes. So you're wondering, wow, this is really, really high. And this will greatly reduce the amount of estate left over to give to loved ones. Is there a way that I can preserve more estate so that I can have more left over for them? There are two common techniques that a lot of people are apply, or they are already doing it and they don't even know. Okay, one is jointly owning assets with someone. Okay, jointly owning assets with someone. So for example, you might have a married couple and they have bought a home together, and on the home ownership deed, the title to the ownership says joint tenants. Joint tenants. It doesn't say percentage, it doesn't say 50-50, 60-40, and so forth. It says joint tenants. And there could be another property, okay, investment property owned by two friends, and on it, it says co-tenants, and it says 50-50, co-tenants 50-50, and it might represent the amount of funds contributed by each investing friend or investor. And so what happens? I'll start with the second example. So when you have the case of investment, so on the deed itself it says 50-50, what happens is, okay, let's say investor one passes away. Investor one passes away. Okay, so when the trustee for investor one goes to the lawyer's office to prepare the probate application, and to do that, the estate value has to be calculated well as part of the formula calculation. Then 50% of the value of that investment property on the date of the death of investor A has to be entered on the application form. So 50%, and then the state administration taxes have to be applied. So let's say it was a townhouse for $1 million, a luxury townhouse, and so it's $500,000 of estate value. And we just saw in the table that $1 million translates to $15,000 in taxes, half of that, because investor A owned half. It's $7,500 in taxes, okay? That has to be calculated. Now let's go to the couple that owns the home as joint tenants. So there's no number on the home ownership. So what happens under a joint ownership rules, under the law of survivorship, when spouse A passes away, the law of survivorship for joint ownership says that the surviving remaining owners, who is spouse B, will own the entire property or entire joint asset. Okay, and just to finalize that process, spouse B should go to the lawyer's office to update the home ownership from joint tenant to registered owner. It's not very expensive to do, but that will have to be done in order to refinance, to sell the property in the future, to just update and correct the proper title to show only one owner. Okay, and so now spouse B owns everything. Okay, and so spouse A doesn't own it anymore because once the person dies, doesn't own it. So that means the estate for spouse A does not own the property, the home. And when the trustee for spouse A goes to the lawyer's office to prepare the probate application, in the probate application, in calculating the value of spouse's A's estate value, there will be zero calculation for home because it doesn't form part of the estate. It has now shifted all of it, and I'm not going to use numbers because they don't use the concept of numbers in joint tenant, all of it to the surviving spouse B. Okay, so that's great, right? So we just saved ourselves that $7,500. Okay, and of course, the higher the value of the real estate property, the higher the taxes would have been. So that's a common technique, and we often get clients who start to add their children on title to their home ownership. So some of my clients who have adult children, they start to look at their estate planning. I mean, they should have started earlier, but this is a good time. After they have paid off their mortgage, they realize that, well, they're going to give everything, including the home, to their children anyway. So let's avoid this estate administration taxes of, that $7,500, right? If by the time of their death, their home is worth $1 million. And let's add our children as joint owners. So when they're joint owners, you know what happens? Law of survivorship, the property shifts to the survivors. It doesn't form the estate of the deceased. And for probate application tax calculation, it doesn't get entered. So 0 times 1.5 is 0. Okay, so that's a common technique. I mentioned doing this after the mortgage is paid off because when you have a mortgage sitting on title, you're not free to just change the name of your home. Your mortgage is attached to the property and the ownership of the property. So if you make a change to the ownership of the property, you have to inform the bank, and the bank has to re-underwrite and reapprove this mortgage and add these children or new owners to the mortgage as new borrowers. Okay, and if they're going to be new borrowers, these new borrowers have to qualify for the mortgage, and these new borrowers are also on the hook for the mortgage. It's a little bit complicated, and during that process, we don't know if it's going to be the same mortgage rate and everything, because this is happening before the term of the mortgage is up, and usually when things change before the mortgage term is up, like it's not a smooth process. There tends to be penalties when that happens. So there you go. Okay. So it's usually, my clients usually do this after the mortgage. We're going to talk a little bit more about joint accounts in a further slide, because there is more that I could talk about on this topic. The next strategy is also known as corporate wills. Corporate wills. It's very popular among doctors and business owners. So what is this? So a corporate will strategy is where a single will maker has two wills. A single will maker has two wills, okay? A primary will, which is will number 1, and a secondary will, which is the corporate will. I just did one for a doctor, and when he was looking at my draft, he said, I wanted a corporate will. I couldn't see it in your draft. And I said, that's a secondary will. It's just that because it's such a common strategy among the health profession, that they just call it the corporate will, but in the legal document, it's a secondary will. Some lawyers have gone ahead and changed the word secondary will to corporate, but all the industry expert lawyers, they still call it secondary will. In a lot of our training courses that we continue to take yearly, so that's why my document says secondary will. So will number 1, the primary will, is like your usual will. It contains everything that you own, and your trustee would take this will to the law firm to get a probate application, calculate the value of the estate, and pay taxes on this value, and wait for a probate certificate to be issued in order to proceed to distribute the estate according to the instructions in will number 1. Okay. Will number 2, the corporate will, is limited to very select items. Okay, it's usually shares of the private company owned by the will maker. Shares of the private company owned by the will maker, which for doctors tends to be medicine professional corporations, or for other health professionals, dentistry professional corporations, health professional corporations for pharmacists. That's the usual. Okay, so actually, will number 1 contains everything except for the items in will number 2. So there's language to sort of remove secondary will or corporate will items. Okay, so corporate will has that. And then what happens is the trustee will have a copy of the secondary will. The trustee will not have this processed for probate. The lawyer for the trustee will not prepare a probate application for will number 2, and the trustee will not receive a probate certificate for will number 2, but the trustee will go ahead and distribute the shares of the private corporation to the beneficiaries. And I might have missed that the estate will not pay taxes on the value of the shares of the private corporation, will not pay taxes on the shares of the private corporation. And why is this so? Why is this so? This is because there is a loophole in Ontario legislation. We can only do this in Ontario. There is a loophole in Ontario estate legislation. It was discovered over 20 years ago in a famous case called Granovsky Estate. Okay, the Granovsky, the will maker, had businesses, and the lawyers for Granovsky read the Ontario estate legislation carefully and saw that the legislation was silent on the need for a probate certificate to distribute shares of private corporation. It was not mentioned. Instead, it was mentioned that you need probate certificate for the distribution of publicly traded shares, that is stocks. It was silent on shares of private company. It was also silent on other things too. I'll mention that later. But because of this, Granovsky's lawyers decided, let's come up with this strategy and go for it. So we're only going to file will number 1 for probate, and we're not going to file will number 2. But we've documented, okay, all of the will maker's wishes in its entirety, because that's what you have to do legally. And it got challenged by the province of Ontario, made its way to the Supreme Court of Canada, who decided in favor of the will maker, Granovsky. And over the years, there has been a challenge and an appeal a couple of years ago, but everything is still decided in favor of this corporate will strategy. So it is good law. My clients use it today, and doctors, health professionals, business owners can continue to apply this strategy. I talked about there are other things that are silent about the need for a probate certificate. Well, what are those? So the secondary will has broadly worded language saying anything that doesn't require a probate certificate goes in here, right? So that allows flexibility. If you know what the item is, you've got the crown jewels, you write it in. The crown jewels meaning the name of the private companies, so forth. But in your life, you can acquire more things. You can start more companies, have more items that fall under this non-existent list in Ontario legislation that doesn't require a probate certificate. So what are those? Typically, those tend to be high-valued personal belongings, such as expensive piece of art. Let's say this monitor is an expensive piece of art. Well, I don't need a probate certificate to transfer it. This piece of art is not registered with any government body. If the trustee sees in my will that 50% goes to so and so, or I wanted to do a detailed will and name that this art goes to child B, for example, then the holder of it can just transfer it. The title to this art isn't registered anywhere. There's no need to go to some government body to say, I'm about to change the name of this ownership. And then the government body replies, well, let me see your probate certificate. There's no probate certificate required. Therefore, there's no taxation required to be applied on the value of this artwork. So your secondary will can include a lot of your valuable personal items. That tends to be ornamental, jewelry, artwork, okay? And if you have a estate located outside Ontario, we recommend that you have a will prepared in the jurisdiction outside of Ontario. There's no guarantee that your Ontario will be recognized outside. There's no guarantee, okay? Even if it is recognized. So for example, sure, maybe another province in Canada might recognize an Ontario will, okay, but there's still going to be a estate application process to recognize a foreign will because the system there isn't directly familiar with Ontario. They're familiar with their province's instruments, and in order to have it fully recognized, they do have to do their own process to make sure it's recognized. There's authentication processes and so forth. This translates into more money, more time, more paperwork, and usually the cost of this procedure is going to far outweigh the cost of just having a locally prepared will in that foreign jurisdiction in the very first place, right? A will is much cheaper than any court process. It'll always be. And this leads us to our frequently asked questions or some common scenarios that clients ask or what attendees at my seminars have asked. So we talked about joint assets and how due to the law of survivorship, your surviving joint owners will own your asset entirely. It won't form part of your estate and won't get subject to calculation in your probate application and subsequently taxed on. Okay. Remember though that when you add people on title, they become an owner, and owners will have control over the decision making of that asset. So you're the owner. When you're the sole owner of a property, you can do whatever you want with it. You want to mortgage it, refinance, or sell it, you can do that. When you have a joint owner, you have to all consent, and you have to sign the documents to sell it, sign all the paperwork at the lawyer's office. You have to make decisions with your joint owners, okay? So you've given up control by adding joint owners. The way around that, and I mentioned about power of attorneys, there's more than just, you can have more than two. You can have limited powers of attorney. You can have a limited power of attorney concerning a specific joint asset. If your incoming new joint owner, such as a child, if you're a parent coming in, is willing, you can have that person, or you can make it a condition upon becoming a joint owner, that incoming owner is willing to sign a power of attorney appointing the parent to be the decision maker for this property, and the original copy is kept with the decision maker. So if I'm the parent, my child has authorized me to do it, I have the paperwork, and then I want to sell it, I go straight to the lawyer's office. Here's proof that the joint owner has given me the authorization to sign on behalf of the other remaining owner, then that's fine too. Okay, so there's that. Another more tricky point is this. So I mentioned that sometimes my clients will come to me after their mortgage is paid off to add their children on title. I would often advise that you add all your children on title. You add all your children on title. If that's your intention, is to share with all your children, not just one child, okay? If you're adding one child, I'll be concerned that there might be a potential family dispute in the future, and I want to keep your records well documented. If that's your wish, you want to give the house to child A and not to B and C, so forth, right? I will really want to document that. But if you only pick, I recommend if you intend on being, sharing everything, everyone is treated equally, you add them all. Okay, you add them all because let's say your will says you're giving everything to all your children, but then you've added your child A as a joint owner, then what happens? Okay, so we already know that according to the probate application, there's no value calculated for the home because now the joint owner, child A, owns it all. Child A owns it all. Child's B and C, they don't own it at all, okay? And it's up to child A to share it with B and C. But once it's owned by child A, there's nothing to ensure that child A is going to go through with the sharing and adding and subsequently adding B and C on title. So do it right in the first place so that you don't have to worry about A going ahead and doing that. Okay, what happens if child A doesn't actually share it? Well, there is a very authoritative case law saying that when a parent has added a child as a joint owner, there is a presumption of constructive trust. Constructive trust, meaning that the child is added for convenience purposes to help handle and manage that asset, not really as a true joint owner, not a true joint owner. And children B and C could easily challenge the validity of this joint ownership. So it's not true joint ownership because common law says that this is a constructive trust only, okay? The child A is actually holding joint ownership of this property as a trust for parents. So child A is not a true owner. If that's the case, then there will be litigation. It will likely be decided in favor of child B and C. If there's litigation, like I mentioned, the fees are very, very high. Okay. So if the will had said everything gets divided equally, that means the case was brought upon for the purpose of protecting the estate's wishes. A wishes said everything gets shared equally. If it's protecting the estate, that means legal fees come out of the estate. So we already heard the cost of legal fees starts at $25,000 and up. For something like this, we're talking huge fees, closer to 50 to 100,000, depending on at what stage you settle at. And so you have the estate minus this heavy legal fee. You need to make an amendment to the probate application because originally the trustee had sought to remove or not include the house as part of the calculation because it was already jointly owned by child A. But because that's wrong now, it has to be amended, okay? More taxes paid. So we're just taking money out of the estate. There's less to share among your loved ones. So be careful and get the advice if you're trying to reduce your probate fees. Next point is divorce. We get a lot of clients who are worried that I've given significant inheritance to my children. Now I'm worried that their other half, or if there's a divorce, the departing in-law might get a share of my estate, and I want my estate to stay in my bloodline. Okay, well, generally, our standard wills are drafted in a manner which says that any gifts that I provide will not form part of net family property. Net family property is a family law concept where when there's a separation, okay, the couple has to calculate what is net family property. It's basically assets that belong to the family. That's just in a very general explanation. Okay, we're not family law specialists, and so your inheritance would generally not form part of net family property. It stays with your child, doesn't get shared with a departing in-law. However, there are a couple scenarios. If your child has commingled and decided to deposit your inheritance into a joint account with their spouse, with the departing in-law, then it's already commingled and it's part of net property. You can't extract it and say it wasn't supposed to be there, okay? The other point is if you gave your house to your child or children and that house gets used or lived in as a matrimonial home for your child and your in-law, the spouse of the child, it's a matrimonial home. Under family law, the matrimonial home is afforded very high protections in Ontario. Matrimonial home for the couple involves that each spouse has an equal right to possession. Equal right to possession, meaning no one spouse can ask the other spouse to leave just like that. It doesn't matter who paid for the house, how the house came to be, that, this was a contribution from you to the child that had nothing to do with the in-law. If the in-law wasn't around, like so forth, it doesn't matter. There's no concept of financial contribution. It's a matrimonial home. It belongs. They each have equal right to possession. So what usually happens in order to sell the property, they both have to consent to selling the property. Usually, if each side would get legal advice. The departing in-law would probably require some funds in order to be willing to sign away on those papers to sell the home. Or if your child decides to stay living in there and the departing in-law leaves, right? Usually in a separation agreement, I've seen that the departing in-law requires a buyout notice. So that means you are essentially sharing your inheritance, okay, with the in-law. Okay, those are the two things, and we do recommend that if you're worried about your inheritance and you want to stay in the bloodline, your children should speak with family lawyers. Okay, there are some documentation, but generally that's how net family property works and matrimonial homes work. Next point is residential trusts for blended families. A blended family is where you may have a couple who each have children from other relationships. And a common scenario is that these spouses get remarried, okay, to different people, and it's possible that this couple, they do not have children together, but they have children from other relationships. And the standard will that I had talked about previously, it might not apply. So the standard will, where there's a couple, they have children together, they may say, I give everything to my spouse. If my spouse passes away before me, I give everything to my children in equal share. And those children are the same children of the couple. They're shared between the couple. Okay. For a blended family, it's a difference. It may be a different scenario. Okay, well, if you try to apply that standard will scenario to a blended family, I give everything to my spouse. If my spouse passed away before me, I give everything to my children in equal uh, share. Well, which children are we talking about? And when you pass away, you don't know what whose children the surviving spouse will give the estate to. And for peace of mind, so that you don't have to worry that your estate doesn't reach your own blood kids, okay, and vice versa, then the standard will for blended family tends to read something like this. I give everything to my children, and I give my interest in the home to my spouse to live and enjoy for the rest of his life. And upon his death, I give my interest in my home to my children to ensure your child is protected. Your child gets your estate and your child gets your interest in the home, and vice versa. And when I say interest, so we talked about joint assets, and we talked about owning a home in percentages. And if that's your estate planning to leave a portion of the home that you're living in with your spouse to your child, then instead of owning your home as joint tenants, you should own it as co-tenants, because that way you can designate 50-50 or whatever percentage you want to put, and you would have a 50% share, and your 50% share would form part of your estate, okay? And your estate would pass according to your will. If it's jointly owned, it doesn't pass according to your will. It goes to the surviving spouse. And of course, you don't want to worry if your surviving spouse may not leave anything to your own blood children. You hope that's not the case, but you don't have that control after you're gone. Okay, and there is that a little bit of a difference because your children are different from different, not together. Okay. So before we open the forum up for question and answers, just to mention to you that during this COVID-19 period, our office is open 7 days a week, just to accommodate and provide more flexibility. And we're offering 3 social distancing methods to have your wills and powers of attorney signed. You can see a picture of our outdoor patio, and this is the traditional method. You would come to our law firm, sign, and we would practice and implement social distancing and have in place hand sanitizers, disinfectant wipes, and you can wear masks, ask you to bring your own pens, and everything will get done and executed properly in this single meeting, okay? Not a big change from your traditional in-person meeting with a lawyer. The second and third method, which we don't have a picture of, and they are more complicated methods, is remote signing and video signing. They are more complicated. Remote signing. This is where you, as the will maker, would get your own witnesses, okay? Your own witnesses. Your witnesses cannot be a beneficiary named in your will, or cannot be a spouse of a beneficiary, and must be 18 or over. You have to ask these 2 witnesses to come to your home or to a place to sign, okay? And you practice your social distancing once you're together. You have to get these 2 people to sign, and we will provide you with instructions on exactly how to sign, where to sign. We do recommend that we supervise by video conferencing so that it's done properly. And after this signing exercise is over, then at least one of these witnesses, they could come to our office, okay, just like that patio that you see, and swear or affirm the Affidavit of Execution, okay, and we'll sign the stamp on the back of the will. Or a witness can go to a local notary public or lawyer and get the same thing signed. However, as I mentioned, I have had to ask clients to go back to their lawyers and get it redone because the stamp wasn't done properly. So if you do go with a local notary or lawyer method rather than coming back to our office, we would provide good instructions on that, but they don't. But to be on the safe side, so you don't have to worry about fixing a mistake and come straight to us. So we rate this difficulty level as medium. You do your own signing, you have to sort of organize things on your own, and then one of the witnesses comes back to us or a local notary or lawyer. The third one is the most difficult method. It's the virtual signing, where this involves, our firm providing the witnesses, myself and usually an assistant or articling student, and you, the will maker. We have to set up 2 video conferences and arrange 2 courier deliveries before this whole will package is signed up. So first of all, we would arrange video conference number 1, where we, myself and the witness, would observe you and witness you signing the will and powers of attorneys over a virtual audio communication platform. Okay, we'll watch you. After we've finished witnessing you, you would have to arrange delivery of this signed package back to our office. Then we have to set up video conference number 2, and you have to watch the 2 witnesses complete the witnessing on the same document that you signed. Then, and between ourselves, the witness and the lawyer, we would complete the Affidavit of Execution and assign the stamp behind the will. We would then arrange courier delivery of this signed package back to you. So we rate this at difficulty levels high. It's more complicated, and it's only available during COVID-19. It's not an option that's always availability. The Minister of Finance issued an emergency ordinance allowing this video signing method. Okay. For those of you wondering, our website is landmarklaw.ca, landmarklaw.ca. We often get asked about our fees. On the left-hand side panel, you can see cost calculator, which you can easily enter and get the standard fees for some of our services offered. And same thing, you can also access our client kits on how to get started once you've decided to use our firm to do your legal work. And our client kits are equipped with a flow chart and timelines and audio instructions on what you have to do. If you enjoyed our presentation, we would love a 5-star Google review. Google Landmark Law, click write a review, or you can access this link, which we're going to put in the comments. And that wraps up our presentation. We're going to now have our question and answer period. We're going to go on a very quick intermission so that we can change the camera settings so that it's just showing, me, and I can access the questions on my computer or phone and bring over a chair. So stay tuned. We'll be right back very quickly. See you soon.